I mean, yeah, hang on.
Is everyone ready? All I ask is that you please use the microphone when asking your questions, please, so that those who are watching on Facebook can have a chance to listen to your questions. We're under a limited amount of time today. The county attorney has a really busy afternoon, so please be mindful of that. Thank you.
Well, good afternoon, everybody. I want to first, since the legislature has adjourned, start off by talking about the past legislative session. It brought some big wins that will strengthen our laws to protect the vulnerable and hold offenders accountable. So there were 3 bills in particular that we worked on. There were others as well, but 3 that I want to highlight. First is Preston's Law, and this is named after 16-year-old Preston Lord, who was killed by a group that assaulted him in Queen Creek in 2023. House Bill 2611, which was sponsored by Representative Matt Gress and others, establishes a new category of crime under the aggravated assault standard or statute. It's called swarming. It elevates attacks by 3 or more people on a single victim to a Class 4 felony, and it ensures that these types of crimes are treated with the gravity that they deserve. This new law is a major step in deterring violent group attacks, especially among teens, before it gets to the point where someone loses his or her life. It's also a deeply meaningful way to honor Preston and to create a legacy in his name that changes our state for the better. The second is Senate Bill 1437. Now, I should say all of these bills are effective September 26th of this year. 1437 will help protect our kids from abuse by strengthening our mandatory reporting law. The updated law now explicitly requires school board members and substitute teachers to report suspected abuse or neglect directly to law enforcement agencies and the Department of Child Safety. Telling a principal, superintendent, or school resource officer or school safety officer does not meet the requirements of the mandatory reporting law. The reason for this is it will help ensure that victims are interviewed by somebody who has been trained to do the investigation, not a school administrator, not a teacher, not an SRO or SSO or school safety officer. We have been seeing too many cases where that didn't happen. When school officials bypass law enforcement, it can be the difference between finding justice for the victim and not being able to hold the offender accountable. And that offender can then go on to abuse others. Now, the third bill, when I say my office is fighting for justice for all victims of crime, highlights I mean all victims, and that includes victims with 4 legs. A new animal cruelty law fills a dangerous legislative void. Senate Bill 1658, which was sponsored by Senator Bullock, will help prevent the needless suffering of pets by criminalizing failure to provide medical care and clarifying the standard for adequate shelter. That means shelter must now be covered, structurally sound, and large enough to allow a pet to stand, turn around, lie down, and maintain normal body temperature. And this is for domestic animals. This is a step in the right direction, but more is needed. The final version of the bill was modified so that it did not include other measures that we need that would clarify that water must be suitable for drinking and food must be appropriate for the species. If that sounds like common sense to you, it's because it is. Providing adequate care for our pets should not be controversial, and I'm hoping that the legislature addresses these things next year. Fixing these gaps in state law will help give law enforcement and my prosecutors the tools that they need to hold animal abusers accountable and protect pets from dangerous situations. Because right now we're seeing far too many cases of pets being harmed. So let me explain. We have a chart up here on both sides. 2023, we filed charges in 37 animal cruelty cases. Last year, we charged 36 cases. 6 months into this year, and we already have filed charges in 25 cases. So that's the darker blue bar on the left side. The lighter blue bar actually shows the number of counts that we have charged. So keep in mind, just because we file one case doesn't mean it's just one count. Also keep in mind that under Arizona law, animal cruelty is not always a felony. So there are other incidents that are charged as misdemeanors that don't come to this office, they go to city prosecutors. To answer a question that I anticipate from you, I can't say if it's happening more, if it's just being reported or discovered more, but I can tell you this. My office and law enforcement in this county continue to make animal welfare a priority. At MCAO, we've built a team dedicated to handling these cases. And so I'm announcing today that we are adding 2 new prosecutors to specialize in this area. They will join the detective, paralegal, and prosecutor already assigned to the team. These are, for the most part, as you can imagine, highly emotional cases, and they can be very difficult to prosecute. And we get a lot of questions about them. People often ask me, or they call our office, what am I supposed to do if I think an animal has been abused? Here's what you can do. Document what you see if you see an animal being abused and call the police. If you are a witness, call the police, stay on the scene, and talk to the police. We need law enforcement involved as early as possible to preserve evidence in a way that is usable in court. If the animal has already passed, don't touch it, don't move it, because you could destroy valuable evidence. Instead, call the police and stay around. Tell them what you observed, and understand you could be giving us the information we need to effectively prosecute the perpetrator. Now I want to move on to our Cyber Predators and Real Risks campaign. My office's goal is to educate parents on the online dangers kids face when they are on social media without safeguards. Here's a question. Would you hand your untrained 16-year-old the keys to your car and say, go have fun? Most parents are going to say no. Hopefully all parents are going to say no. But every day, parents hand their kids phones, tablets, and laptops and gaming devices and expect them to know how to navigate the online world safely. And that's just as dangerous. Just like we teach them how to drive safely, we have to teach them how to use technology safely. So when you hand over a phone or a tablet, it needs to come with a conversation and a set of expectations. It doesn't mean you don't trust them. It just means you're involved and you care. Now, if you turn your attention to one of the screens, I will show you a quick video about how you can do just that.
Don't give them a phone for their birthday or for Christmas, because then it's a gift, right? And then it is theirs. And it's really confusing for your child, even if your child is 16 or 17, to be like, this was my birthday gift, and now you're saying it's yours. Spot checks are incredibly important. Going through that phone at very random times, often. So it's randomly at 9 a.m., let me see your phone. Randomly at noon, you know what, you're not taking your phone today. I'm gonna have it. You know, and just really instilling in them, this is not your phone. You'll get a phone, but right now, this is like the training phone.
Sorry? Okay. The full version of that video and other videos are on the Maricopa County Attorney's Office website, along with other information about protecting your kids against cyber predators. So by watching these videos, you'll learn some simple ways you can stay on top of what your child is doing online. And with that, I'm ready to take your questions. Hi.
Hello. Hi, I'm Nicole Santa Cruz.
Oh.
Whatever.
You can turn it down. I have to do that every time myself.
I don't know how to. I guess I can.
Okay.
ProPublica, and we just published an investigation along with ABC 15 about the death penalty and how 13% of cases, only 13% of cases resulted in a death sentence. We also had one of your predecessors calling for more transparency into that process, and I'm just wondering if you had any comment on that.
Well, first of all, there has never been a county attorney that's more transparent about the death penalty. We have released part of our policy that governs it, and we've made it very clear that the person who makes the decision on whether to pursue the death penalty is standing right here. It's Rachel Mitchell. I have stood here many times and discussed in detail the thought process I go through in considering whether the death penalty is appropriate to seek. Obviously, additional information can come in the case. These cases sometimes last 4 or 5 years, and I'm going to continue to consider that information. So we file a public document that talks about the aggravators that we're relying on for the death penalty. The death penalty is ultimately, as you know, decided by a jury. It's decided in open court. So I think it is an extremely transparent process.
What about the 13% number? Do you think that should be higher, or are you satisfied with the rate at which the office obtains death sentences?
You know, I don't look at numbers, I look at cases. And if information comes after the death penalty has been sought that justifies doing something different, we're going to do that. I am never going to be the kind of county attorney that says, once I allege the death penalty, that's it. I'm not going back. That's not ethical, and that is not how I practice law.
To follow up on that, the 13% number, I mean, when your office, the county attorney, whoever it may be, because there have been many over the years, make these determinations, that decision can last for decades. It costs this county millions of dollars. So when you talk about looking at cases, not numbers, the number is 13% of them only results in death, but yet hundreds of millions of dollars have been spent on cases that don't end in death. Does that concern you in any way?
You know, one of the things that I take into account are resources when I'm authorizing a notice of intent to seek the death penalty to be filed, but it is not the only consideration. I'm looking at the nature of the offense, the strength of the evidence, and then, as I said, anything that continues to come in. These cases, as you know, can last for many, many years. You can get some additional information, and I'm always going to keep an open mind. It's appropriate.
So then my last follow-up question on this would be, we asked your office for kind of an accounting, and we're hoping to still get it because we filed a public records request for how much the defense knows, but not your office, how much this has cost death penalty cases over the years. Is that something you'd like to know, or is that not something you're concerned about?
Well, the difference in that is the defense attorneys who do this work bill by the hour. My attorneys do not bill by the hour. And so it's going to take longer to get that information to you. But as you know, you asked a lot of questions, Dave, and we answered them sometimes in pretty much detail. So we're working on it.
I appreciate that. We also heard that you had some concerns about our reporting, that it wasn't accurate, but then when we followed up, we got nothing to add. So is there any concern about what we reported?
What I would say is when you ask that much information and we put that much effort and time into giving you the details, I would have expected to see more of that information in your reporting.
I'm not sure what you gave us that you think we didn't include. You didn't get into the numbers at all. You didn't, sit down for an interview, so I'm not sure what you mean by that.
Well, I've got some of the give and take between you and my comms department, and I don't know which one's your...
you for months.
I don't know which one is your camera, but if you want to look at all of the red and the blue on this is us responding to all of your questions, page after page after page. So I think we have been very much responsive to you.
I would think that's actually not true. I think the only general answer you gave was that you stand by your prosecutor's work over the years, and that's really about it. Didn't respond to any of our specific findings at all, and that record shows that.
Well, there's more blue than that, so I disagree.
Okay, thank you.
Hi.
County Attorney, how are you?
Good, how are you?
Good. I had a couple questions about 2 drowning cases. Hopefully I can get a third in about another case. There had been a recent submittal from Chandler Police for a Class 4 felony charge against a gentleman named Brady Keiser, and his wife is a very well-known member of the social media community. I'm wondering if there's an update you can share with us and the community about where your office is at in making a determination on that case.
Sure, that case was submitted to us for 1 count of child abuse under a criminal negligence theory of the case. It came in this week officially, and so we're in the process of reviewing it. It's going to take some time.
Sure. If I can ask this, with a Class 4 felony child abuse charge, as Chandler Police have submitted it, what evidence needs to be there to prove that case beyond a reasonable doubt at a potential trial, could you say, especially with the drowning?
Yeah, I don't want to speak to this case in particular because I haven't had a chance to review it myself, but let me give you an overview. Because I think there is a lot of misunderstanding about this area. First of all, people need to understand that not every tragedy is a crime. I mean, it's heartbreaking. My heart goes out to the situation. But there's a difference between civil negligence, where you can sue somebody, and criminal negligence, where you can prosecute someone. So let me kind of differentiate between those two. Civil negligence means that someone's carelessness results in harm to another person. So if you're the attorney on that, you have to show that the person had a legal duty to that person, that they breached that duty, and because they breached that duty, that person was harmed. A very simple example of that would be you have a duty to obey traffic laws when you're driving. If you run a red light and you hit somebody, you've breached that duty, you've caused harm. Criminal negligence is totally different, and that's what we're looking for. That's what we have to have to file charges in this case. Criminal negligence means that the person fails to perceive, so they don't perceive a substantial and unjustifiable risk that the result will happen. And I'm going to read directly from the statute here because this is what we're looking at when we're looking at these charges. The risk must be of such nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that a reasonable person would observe. Without commenting on any specific case that's ever happened in Arizona, an example of that might be somebody who drives past flash flood warnings and they proceed into a wash and they have somebody in the car with them, a child in the car perhaps, and they go into that wash. Most people would heed those warnings, so you could argue that by proceeding into that wash, there is a gross deviation from the standard of care. So those are the things that we're looking at.
Understood. Quick case in Peoria, there is a submittal to your office about a neglect charge related to a 12-year-old who may have been left in a above-ground pool. Is there an update you have on that case at all?
Actually, I don't think we've received that submittal yet.
Okay, good to know. We'll go back to police. Third, and then I'm done.
Okay.
Adam Sheafe case. He is waiting extradition back to Maricopa County from Coconino County. He has spoken with every single news station in the Phoenix market about what he did or is alleged to have done to a New River pastor. I would love to get your reaction, if you can, to what he has claimed and how that may play into a potential charge for him.
Because of the status of the case right now, I really can't comment that much. I'm aware of the interviews. What I would say is stay tuned.
Thank you.
Hello.
Hi.
So a question about the drowning case involving Brady Keiser and the other drownings that were just asked about in general. What's your threshold for charging a parent that loses a child? Some people believe they've suffered enough.
Mm-hmm. Well, I mean, the basic threshold obviously is what the law requires. You know, is the gross deviation from the standard of care, did that occur? Was there a substantial and unjustifiable risk? I think what you're saying is, you know, do I take into account that maybe some jurors would consider that the parent had suffered enough? And my answer to that is yes and no. No, in the sense that it doesn't factor in as to whether the person satisfies the requirements of the statute. But yes, because the filing standard for this office is a reasonable likelihood of conviction. And if after reviewing the totality of the circumstances, and let me just say, every case is unique, we feel like that jury might or is likely to find the person not guilty because of that reason, then we have to take that into account.
And you just don't know at this point because, like you said, you haven't reviewed it yet.
Correct.
Okay. Accused kidnapper Timothy Wood.
Mhm.
Can you talk about the decision to not prosecute that case, especially in light of his previous convictions abusing women?
Well, let me correct you. We didn't make any decision to not prosecute him. What we did was we asked for additional investigation from the police department. As I've said many times up here, we get one chance to do this right. And the allegations are very serious. And so sometimes we as prosecutors who have been in the courtroom see things that we want shored up before we proceed. And so we send it back to the police to do some additional investigation. That's not to say that they didn't do a good investigation in the first place. It's just perhaps we've seen other angles of it. Secondly, the prior history that you're talking about, while it's important in determining, for example, how this would be handled sentencing-wise, I cannot use prior convictions to prove that he committed this offense. I have to have evidence independent of that he committed this offense. And so that's what we're shoring up.
Are you able to be specific at all about what additional evidence you're looking for from police?
Not at this time, no. I mean, with an ongoing investigation, it wouldn't be appropriate.
And obviously the Sheriff's Office has had a federal monitor for more than a decade at this point. Do you believe it's still necessary?
No, I don't. This was a situation that was put in place under somebody that was sheriff 3 sheriffs ago. He was voted out of office. He was replaced by somebody from another political party. And interestingly, and really tragically, that sheriff ended up resigning from his position because he felt so constrained by the monitor that he wasn't able to do his job. And the system worked in the sense that we voted out the person that was the focus of this monitor. So we need to move on. This $350 million is not making our community safer. And in fact, all of the other places where this monitor is involved has dragged on even longer than 11 years. For example, Oakland, where he is also the federal monitor, has been over 20 years. It doesn't make the community safer. And as a taxpayer, $350 million could be spent a lot of ways to make our community safer.
But if this monitor says that there are still violations happening within the department, shouldn't those violations be addressed?
This monitor has a financial incentive to continue to find violations and noncompliance, and that needs to be taken into account. We have paid, the county has paid this monitor just shy of $30 million at this point. If he finds compliance, he's out of a job.
Thank you.
Mm-hmm.
Hi, Valman Bristol's KTR News. Just wanted to ask about your thoughts.
I would never have guessed that from
Oh,
him.
I know. I just wanted to ask your thoughts on the Preston Lord trial for the 6 of those suspects being delayed, and just any insight you can share into why that may have happened, or any other thoughts you want to share on that.
Well, if you remember when we first got the submittal back in December of 2023, a lot of people were wanting very quick results on that, and I stood at this very podium and I said, this is a huge police report. It's got 600 videos and many, many other pieces of evidence. And so now the defense attorneys have requested for additional time to prepare their case. You know, while we want to get swift justice for the victim and certainly his family, it's been going on a long time for them. I understand that. It is a very complex case, and so a 6-month continuance was granted.
Awesome. That's all I had. Thank you.
Mm-hmm.
Hello, Lindsay Regis at Fox 10. This
Hi.
is a follow-up to, it's a drowning question.
Mm-hmm.
Has anyone ever been charged and prosecuted successfully for a child drowning?
Yes, I'm trying to remember any specific names for you. We'd have to research that, but yes.
The reason I ask is because we follow these stories a lot, and we don't really hear that the dad or the mom is arrested later, and we're wondering, is it because this is Emily Keiser is so well known, her husband's well known, and their kiddo?
I don't have any information to think that that was the police motivation for that.
Do you know when you'll make a decision?
We're set to start reviewing it as soon as possible. Like I said, we just got it this week, but I can't say, because I can't say that we won't ask for additional investigation. I just don't know at this point.
Thank you, that's all I have.
Mm-hmm.
I also had the same question, but
Same answer.
Yeah. Save some time. I also had a question about the monitoring of the meeting last night. I was curious if you plan to file a motion or any sort of legal action on your end to work to end the court order that does that. I know that the monitor has gotten a lot of criticism, but from your end, is there anything that you view that you can do to end this process?
Actually, in my capacity as county attorney, I've appointed an attorney or attorneys to represent the sheriff's office. And I've also appointed an attorney to represent the Board of Supervisors, because they're obviously the ones that have to pay the bill. So I will leave it up to those attorneys to decide legal strategy on that.
Okay, so that's under your office, but independent of you specifically?
Yeah, independent of me.
Okay.
Yes.
Thank you.
Ms. Carney, I actually have one follow-up question on behalf of a colleague, Ashley Holden. She wanted to know, in the Mercedes Vega case, there were charges recommended against Cudjoe Young. Where does the review stand for those charges?
I think it is under review. Yes, it's under review.
Okay.
All right.
Thank you, everyone.
Anybody else? All right. Thank you.